Well, good morning. Thank you very much for joining me on this video. I want to talk to you today about signing an agreement of purchase and sale. Now, actually, a couple of years ago, we took an in-depth look at the assignment of an agreement of purchase and sale. I'm not going to do that today, but I want to touch on it, and there's a number of ways it can be done. There's a division in the legal community as to whether or not a buyer, and I want you to imagine that a buyer enters into a contract to purchase a property, and then he is approached by a third party, or he deliberately markets the property. Anyway, he's got somebody who wants to pay him substantially more and take over his agreement of purchase and sale. Can he do it? The legal community is somewhat divided. Some lawyers feel like, no, the seller has covenanted with that particular person and the seller can force that person to buy, and if he wants to turn it over to somebody else, he's got to close and then resell it. And of course, he's going to incur legal costs, he's going to incur land transfer tax and so on. A larger segment of the legal community says, no, it's contemplated in the agreement of purchase and sale. The buyer has a beneficial interest in that property and he can market that. So he can actually sell his interest in the agreement of purchase and sale, not close, and the new buyer steps into his shoes. And the Ontario Real Estate Association has developed Form 145, which is an assignment of agreement of purchase and sale, which specifically deals with that. The property goes up in value, and the buyer decides he wants to spin it off and find a new buyer who's going to step into his shoes. And if you look at the agreement of purchase and sale assignment 145, it contemplates two purchase prices, the original one and the lift purchase price. It contemplates two deposits, the original deposit and the deposit that the second buyer puts up. It contemplates two commissions, the commission that the first agent earns for doing the deal, the commission the second agent earns for bringing in the third party, and so on. And so it can be done. What I want you to understand, though, is if the person who is taking over the agreement of purchase and sale fails to close, the seller isn't going to sue the secondary buyer. He hasn't got any contract with a secondary buyer. He's going to sue the original buyer. So if the buyer has assigned it to somebody else and that somebody else doesn't come to the table on closing, the first buyer needs to close on his behalf and then go after the second buyer. So he's still on the hook, as it were. Another thing that can be done is we can have the person's name in trust. Back before electronic signatures, back before email, going way back before faxes, it was common if a buyer was out of town for the realtor, and I never endorsed this, never encouraged it, but the realtor would sometimes put his own name there and add in trust. And he was notifying the seller that he wasn't going to be the buyer, that there was a third party that was going to be the buyer. And so he would say, John Doe or Wayne Quirk in trust. Understand, if you use, this was the liability that I tried to explain to agents when they did this on behalf of my good client. If the good client changes their mind, walks away, doesn't come to the table, the person who signed the agreement of purchase and sale is very much liable to complete the transaction. Even though it says in trust, and you're telling the seller that I'm going to be putting somebody else's name on there, the buyer who signed the agreement of purchase and sale is liable. But I've also seen it state this: in trust for a numbered company to be formed. Now, if you state that on the purchaser's line, what you're saying to the seller is that the buyer is going to be putting it in a numbered company that hasn't yet been formed. He's going to be putting it into a shell company that has no assets. And because you put the seller on notice that you're going to be doing that, the buyer who signed the agreement of purchase and sale is no longer liable. He puts it in the name of a company, and then that company fails to close. The seller would have to sue the numbered company with no actual assets. And so, on the other hand, you can say on the agreement of purchase and sale that the person buying it is named or assignee. And that's very much as stating the previous thing we looked at, where we said it was going to be a numbered company to be formed. If I've told the seller that it's going to be me or an assignee, I am putting the seller on notice that I have the right to transfer it to somebody else. And now the difference between that and the 145 is that I have no longer any liability. I have transferred it to a third party, and that third party is now liable to the seller. The seller can go back on the third party, but not on me. And so I would want to caution you, and this is what I want to leave you with here. If you set up an agreement of purchase and sale, and the buyer is either stating that it's in trust for a numbered company, or the buyer is stating that it's him or an assignee, if you're looking after the seller, don't leave it at that. What you want to do is you want to add a clause saying, however, the original signator, and then name him, John Doe, shall remain personally liable for the fulfillment of the contract. Now, if the signator, the guy signing the contract, doesn't want to sign that, you've got to question his integrity in moving forward in the deal. If you're looking after the best interest of your seller, you want to protect your seller, and you want to hold the person signing the contract liable, or don't put "or assignee" in there. And you say, well, Wayne, you said right at the start they could assign it anyway. Yeah, but the original signator is responsible in that case where the seller didn't agree to the assignment. So if you're going to allow your seller to agree to the assignment, add in there that clause that states the original signator shall remain personally liable for the fulfillment of the contract. I hope that all makes sense. Thank you very much for watching this video. Be sure to join us again next week.